Thank you, Mr. Chairman, distinguished panel members. Good morning, ladies and gentlemen. In the time given to me, I wish to first speak about the Commonwealth Lawyers Association as an organization that represents 56 of the Commonwealth jurisdictions and countries. We carry a very strong rule of law mandate throughout the Commonwealth countries. And what is known as the sovereign debt crisis, or really the sovereign debt default crisis, is a rule of law issue. Undoubtedly so. And why is it a rule of law issue? Because one of the things that the rule of law prohibits is arbitrariness. And what we have in terms of sovereign debt and the treatment of sovereign debt defaults requires a coherent international framework founded on international law to prevent this arbitrariness. Now, this coherent system is something that should be under the aegis of the United Nations and not under the control of any of the so-called borrowers. Why? Because we heard this term being used just now by Mr. Chairman, that there are predatory lenders. What are predatory lenders? These are persons who have strong economic power, and because these borrowers have strong economic power, they can impose unfair terms on borrowers, and then they hold borrowers to ransom. Now, that is really the general framework, the general concern of sovereign debt and the sovereign debt default crisis. It does take countries into severe problems, social and economic problems, and indeed even legal problems. It shakes the very fabric of society in most countries. But this morning, I wanted to speak to you about a slightly different aspect of the sovereign debt crisis or sovereign debt default. And it's got to do with the use of sovereign debts for an improper purpose. Now, we all know what sovereign debt is. It's where the sovereign borrows for the benefit of the country. It is intended largely for long-term economic development. Instead of borrowing locally, it borrows overseas. Funds come from overseas, and it is meant to assist the country. But what happens when sovereign debt is used for an improper purpose? It is a rule of law concern because it's a violation when the sovereign debt is not used for proper purposes. It is an instrument for corruption and abuse of power. It has been described as a kleptocracy. What's a kleptocracy? Kleptocracy is where agents or officials of the state appropriate funds or assets belonging to the state for their own purposes. It's called a kleptocracy because it's done by the agents of the state. And what's the asset here? The asset here is the fund, is the borrowing. What is borrowed by a country ostensibly for the use of the country is then becomes an instrument of abuse in the hands of the officials of the government, and mostly the officials. Now, one of the greatest kleptocracy in recent times is one that happened in my country. It's called the 1MDB saga or fund. What was intended, and again, the intentions were altruistic. It was intended that those funds were to be used for the long-term economic benefit of Malaysia. On paper, nothing wrong with it. But what happened was, through a series of opaque transactions and layered borrowings, spanning not one jurisdiction but many jurisdictions. I do not have time to get into all those jurisdictions, but you will read about prosecutions in Switzerland, indeed prosecutions in Malaysia, in Singapore, and so on, spanning all this jurisdiction, and importantly here, with a complicity of international bankers. Some of the well-known banks in the world were complicit in this. We had the largest, possibly largest scale embezzlement of funds, mismanagement of the funds. The funds were used for personal purposes of state officials, in this case the former Prime Minister of Malaysia, and as political patronage. Now, sovereign debt, to be very clear, is not meant for that. It is not meant for personal use. It is not meant for political patronage. How could this have happened? How could the international community have missed this? It is something that started in 2012, and when the news actually broke, it was sometime in 2016 when it broke internationally. When it was simmering locally, the government of the day put in place oppressive laws so that this will not come into to play. Yesterday we heard about POTA. POTA was used in Malaysia. We have the Sedition Act in Malaysia. The Sedition Act was used for those people who spoke about this. We have a law called SOSMA, which allowed for detention without trial. That was used, and a whole host of penal code provisions were used against anybody and everybody who sought to speak about this crisis that was looming in the horizon. Now, the effects of it is the same effect that you speak about a default. Generations of Malaysians are today lumbered with this act of corruption. We face the same downfall that you have when when states cannot meet their obligations under the fund. The break came in 2016 when despite all the issues that were raised locally, despite all the concerns that were raised locally and which were all just stamped, the break came in 2016 when the US Department of Justice, and they have this initiative which is called the Kleptocracy Asset Recovery Initiative. All right? So you see, it's something at the international level. It's beyond the country. It is not within the control of any of the borrowers or lenders certainly. It is taken out. They came out with an expose where they were able to show how these funds were misused. They were able to trace how the beginnings of the fund, how the funds were moved from jurisdictions to jurisdictions, how banks were complicit, where the monies went, and short of naming the culprit who they call MO1, all right, which is Malaysian Official 1, and it didn't take a genius to figure out who is Malaysian Official 1, given all that had come out, they fingered and pointed to who was responsible for this. That happened in 2016, and despite that, we had no change of government until 2018. But in 2018, when there's a change of government, the former Prime Minister was prosecuted, and certainly others were prosecuted. And one of the spin-offs of those cases, he was convicted, 12 years imprisonment, and then he was pardoned. He's gone down to 6 years now or so. He's facing another prosecution for 1MDB. Malaysia has put together domestic laws that will curb, curtail, and have oversight over public financing. But having said all of that, and in this very short time, I just wanted to highlight to you that until and unless we have a coherent international law system that looks at first how sovereign debt is acquired, secondly, how sovereign debt is used, thirdly, how sovereign debt default is managed, the 1MDB saga will not be a one-off. So long as these loopholes exist, it will recur. The avarice of man is such, the greed of man is such, that this is an opening. Mind you, if 1MDB was repeated in any of our local jurisdictions, in other words, the funds were not sovereign funds, they were local funds. Do you know in most of our jurisdictions there's enough oversight, enough curtailment to prevent something like this happening? They would have been caught. Whether you take your insolvency laws, you take your bankruptcy laws, you take all the borrowing statutes that you have in your countries, they have enough mechanisms to at least put a check on this. But it's a free-for-all out there in the international arena. It's a free-for-all. So on the one hand, where we are looking for some sort of accountability as to how sovereign debt is managed, and so that generations of the members of the public in that particular country do not suffer. On the other hand, let us never assume that it cannot be abused. I'm here to tell you the 1MDB experience tells us that it can be abused. It can be misused in the hands of the powerful. And those who end up, as it said, carrying the can is you and I, members of the public. Thank you very much.